For today's story, we discuss a woman who was convicted, sentenced to death, later found out the police were lying, and now wants to sue. Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. But first, a huge thank you to the sponsor of this video, Aura. Aura is a new type of security service that helps to protect your online accounts, internet connection, and devices with one simple subscription. With an easy online dashboard and alerts sent straight to your phone, Aura keeps you in control and guides you through solving any issues with Aura's excellent customer service. All plans, of course, come with $1 million in identity theft protection insurance and an experienced US-based customer support team that has got your back every step of the way. So if you want to secure your online presence from hackers, scammers, and nosy advertising companies, please go visit aura.com/uncivillaw. And when you use my link below, you'll get up to 40% off all plans. Plus, there's a money-back guarantee. So if you don't like aura.com, you can cancel and get your money back. aura.com/uncivillaw to help you protect your identity and your credit from increasing threats in our increasing digital age. For today's story, we're discussing Deborah Jean Mielke and the city of Phoenix. Deborah Jean was convicted of murder and sentenced to death, but then found out that the detective lies. He lies a lot. He lies like all the time. So her conviction was overturned. Now she'd like to sue the detective for, the lies. So can she sue? Let's get started with this. Deborah Mielke brought various claims under 1983, as one does. As the district court found, she and her lawyers knowingly and willfully obstructed discovery and destroyed an extraordinary amount of physical evidence and some electronic evidence. The district court did not err in so finding. The misconduct was so extensive and prejudicial, the district court held it required the case to be dismissed with prejudice. We have jurisdiction to affirm, and we do so. So, as it turns out, both sides were doing some bad things. Not necessarily saying these two sides are equal, but both sides were violating the law. So yeah, when the prosecution convicted them with the false testimony of the detective, that was bad. But then when she sued, you know what she decided to do? Destroy evidence and obstruct hearings. So, she loses her case because of obstruction of her own civil case. So one bad turn turns another, I guess, or something. Mielke served 2 decades in Arizona's death row for the murder of her 4-year-old son. Although no physical evidence linked her to the crime, she was convicted after police detective Armando Saldate Jr. testified she confessed to the murder conspiracy. The court granted Mielke conditional habeas relief because the government had prejudicially failed to disclose the detective had a long history of lying under oath and other misconduct. Yeah, the only real evidence against her was a confession from the police detective who has a long history of lying under oath and other misconduct. So, after serving 2 decades on death row, her sentence was eventually overturned. In 2015, Mielke sued the police officer, a police sergeant, the city of Phoenix, and the county, claiming she had been unconstitutionally incarcerated. As the district court noted, her central claim was that Saldate fabricated her confession. This case proceeded for 5 years. That's a long time. The district court found that Mielke had committed egregious discovery violations, including willful and intentional destroying both of physical and electronic evidence and repeatedly making incomplete and inaccurate discovery responses. The evidence that Mielke destroyed include boxes of documents she had collected while in prison, and Mielke's deceased mother's boxes of documents concerning the criminal and habeas cases. Mielke and her lawyers also directed the destruction or removal of a website and social media pages about her case. The district court did not err in the making of these findings. So, for whatever reason, and who can say, but for whatever reason, when she decided to sue the officer for the lies that put her in prison, she destroyed lots of evidence. She destroyed evidence of social media pages. She destroyed evidence of cases. She destroyed evidence of lots of things. So this case dragged on for 5 years because of discovery abuses she created, discovery abuses that she directed and her lawyers directed. Now, why they were doing these things, I don't know. But they were doing these things, and the district court at one point just eventually gives up because of all these discovery abuses. And it happened to Alex Jones as well. And similarly, like there were a whole bunch of discovery abuses from Alex Jones and all kinds of things and all kinds of remedies. And eventually the district court just eventually gave up and said, yeah, we're just going to find you liable now. The district court correctly found the public interest in expeditious resolution and its need to manage its docket support dismissal because the case had been pending for 5 years. The district court had been unable to close discovery after 5 years. That's amazing. The district court did not clearly err in finding Mielke's destruction of evidence prejudiced defendant's ability to proceed to a fair trial. One would think, if you destroy evidence, it kind of makes the trial less fair. The central factual dispute involves whether Mielke, or Saddle, was telling the truth about whether Mielke confessed. Thus, just as evidence bearing on Saddle's credibility was critical, so too was evidence bearing on Mielke's credibility. Yes, in a civil case, right, different standards of proof. So whether or not, for the purposes of a criminal case, there's requisite evidence with all this prejudice is one thing. But also, we have to evaluate differently under different standards in a civil case. And you are destroying evidence that would help the jury to evaluate your credibility. We emphasize, as did the district court, that Mielke's willful destruction of evidence was extraordinary. Thus, the district court did not err in finding prejudice. Yeah, when you try this hard. The district court first considered imposing costs and attorney's fees on Mielke. The defendant sought $600,000 while Mielke proposed $150,000, asking Mielke to report her total assets, an expectation of about $96,000 from her mother's estate, so she's basically broke, and determining Mielke could not satisfy even her own low suggested award. Mielke proposed dismissing her coerced confession claims, dismissing the police sergeant, or giving the jury an adverse inference instruction. So adverse inference is available in a civil case, not a criminal case. And one of the things, it's not an automatic, but it is one of the things you can ask for. It's you destroyed evidence, therefore the evidence would have been against you. So that's an adverse inference instruction. It's where the judge says, this evidence is not available. You, the jury, can infer the evidence was against the party who destroyed it. You can infer this evidence would be bad for them. The district court assessed the coerced confession claim as weak because Mielke had written to her retrial counsel that the detective read the Miranda warning twice and then told him that she understood the rights. And Mielke also gave conflicting accounts of invoking her right to counsel. The district court found dismissal of the defendant was insufficient because the claim against him was an insignificant part of the suit. Thus, the district court did not err in finding last drastic sanctions were unavailable. Had Mielke and her attorneys either satisfied discovery obligations or even committed less egregious violations, the lawsuit would not have been dismissed, but they chose to destroy evidence and obstruct. Therefore, the district court properly found the court did not abuse its discretion in dismissing this case with prejudice. Thus, that brings us to the end of discussion of the case of Deborah Jean Mielke and the city of Phoenix. In this case, Mielke was convicted. She was sentenced to death. That is bad. 20 years later, she was set free because the detective lies and lies a lot. She wants to sue. Unfortunately, she knowingly, willfully, purposefully destroyed evidence, lots of it, repeatedly, despite the district court's many, many attempts. And so the district court, says eventually, I give up. It's been 5 years. I'm still in discovery and there's no end in sight. And I've tried everything. I just give up. So I'm dismissing with prejudice for the discovery violations. She appeals and the Court of Appeals is like, yeah, no, they're not an abuse of discretion. It's an extreme sanction, but there's fair amount of evidence to support it. And even if the Court of Appeals would have done something lesser, it's not an abuse of discretion. So no recovery for the 20 years in prison against this detective. And that, for the moment, leads us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.